list applicable to the situation. If you didn't have pandemic, quarantine, those kinds of things, but you had government orders or acts, ACTS, that might work because there certainly were a lot of government orders in place for both on a federal and state level. Acts of God probably aren't going to get you there for a COVID-19 thing. We'll get to catch-all phrases in a minute, and maybe you got some luck there. Uh, Catch-all phrases, you might read any other cause beyond the party's control. Maybe it reads any like cause. Maybe it reads any other cause, whether the kind enumerated or otherwise, etc. So back to my point that, yeah, it's boilerplate because most contracts have a force majeure, but they're all over the map in some of these clauses. And state law sometimes comes into play no matter what your contract says. Some states require that regardless of the contract verbiage and the catch-all clause, the event that we're arguing about had to be unforeseeable. In some states, you're about to learn a new phrase here probably. Some states apply the contract interpretation doctrine of ejusdem generis. Yes, that's fancy language for this. That's what it means. It means if there's a list of events followed by a catch-all clause, things within the catch-all clause have to be like the things in the list. And so sometimes if you're in one of those states, even though you've got a wonderful catch-all clause, you might be out of luck. It just depends on what your contract says. So we got to look at the laundry list. We got to worry about what state we're in. We got to worry about the catch-all phrase. And then we also have things like, what is the triggering measurement? Was it when performance becomes impossible? Is that what your contract said? Is it performance is not reasonably possible? Performance is impractical? Party is prevented from complying? You could probably see in these different phrases that, if you had the first one, for instance, performance becomes impossible. The other side's going to argue, well, technically it's possible. You don't want to be in that situation of arguing over the technicality. So we want to work on what kinds of wordings we put in our force majeure clauses. What's the required notice? Promptly, immediately, as soon as practical, within a certain number of days. I like the last one because it would say, for instance, within 10 days, within 30 days, whatever it says, you can measure that if you know when it started. As soon as practical, lawyers will argue about, well, what was that? Immediately? Does that mean like bam, right now? Or what does it mean? Promptly? What's promptly? And so you worry about these kinds of interpretations of these loosey-goosey words. I like the last one best. We'll come back to that in a little while. When did the notice period begin? Even if you had the one I like within X number of days, when did it begin? This example scenario, COVID-19, did it begin when China issued a no travel order? Did it begin when the World Health Organization said there's a worldwide pandemic? Was it when President Trump or the CDC entered some advisories? Was it when your state governor issued stay-at-home orders? Was it when your county judge did? You see the problem. If we have a kind of a loosey-goosey scenario there, you're going to be arguing with the other side of when the notice period began. So here's some suggestions. Include, going forward, obviously, pandemic, epidemic, infectious diseases, communicable diseases, those sort of things. Before COVID-19, most of us never thought about that, lawyers included, because it just wasn't something that we thought, there was the 1918 flu thing, but there hasn't been that kind of thing since. So we didn't see the urgency of including these kinds of words in the laundry list of the force majeure clause. We do now. It's a lot like 9/11. Prior to 9/11, you seldom saw acts of terrorism in force majeure clauses because here's the thing. We never thought that possible in this country. We found out it was possible. So after 9/11, you commonly saw in force majeure clauses acts of terrorism. Now, because of COVID-19, you're going to commonly see these things going forward. That's what I mean when I talk about contracts evolving. Things happen. My parents divorced when I was 4 years old. I've seen the divorce decree, and it's a couple of pages in 1964. Most divorce decrees these days, when kids are involved, are 20 to 30 pages. Things evolve over time. Same with our handy dandy little force majeure clause. Go ahead and include government orders or acts. That's probably, well, I shouldn't say probably, that's in most cases in force majeure clauses these days, but obviously that would have helped. Make the notice period what I said was my favorite, the within a certain number of days, because we can measure that. It's a simple thing. How many days? And include verbiage allowing for rescheduling. That's kind of a different thing, but we're gonna hit on it in a few slides. Where do you want it to cancel? Probably not. Yeah, you might, but probably not. So include verbiage about rescheduling. Here's a new sample I would give you. And by the way, there's a lot of words on some of these slides because we're talking about contracts. It wouldn't be as helpful to you to show you a picture of something necessarily. So excuse me for the wordy slides, but we'll get you copies of these slides and you'll have all this. So, the thing starts out, neither party will be liable for failure or delay to perform obligations, blah, 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 which have become practically impossible. Uh, I don't even know if that word is spelled right, but anyway, you want it to be, you want a little wiggle room, but you don't want to be having to have to prove that it's literally impossible. You don't want that because, most things you could find a scenario in your mind where it would be technically possible. So maybe you use this phrase. You're going to include government orders or acts or orders, epidemics, pandemics, outbreak of communicable disease, quarantines, national or regional emergencies. Those things would have helped. Or any other cause, whether similar in kind to the foregoing or otherwise, beyond the party's reasonable control. There's a couple of things there I want to point out. You remember I told you about state law, where sometimes you got the state arguing that, well, we don't care what your contract says, it has to be the kind like the list. This might help persuade a judge or jury if you have this in there that says whether similar in kind to the foregoing or otherwise. And instead of holding you so tightly to it, beyond the party's reasonable control. Because again, if it simply said beyond the party's control, you've got this argument about, well, they could control in this scenario. You don't want to have to fool with that. Is it your reasonable control? So that would be helpful to you. Written notice must be given no later than 10 business days following the force majeure event. Again, I'm choosing the certain number of days. And notice I said business days, not just days. There's a difference there. You don't want to maybe be counted against it if it's during the holidays, that sort of thing. You want to talk about business days. And maybe 10 is not enough in your scenario, your business, your industry. Maybe it should be 30. You decide. Here's some additions that I would encourage you to have going forward. All delivery dates under this agreement affected by force majeure shall be tolled, meaning they're put on hold for the duration of such force majeure. The parties hereby agree, when feasible, not to cancel, but reschedule the pertinent obligations and deliverables for mutually agreed dates as soon as practicable after the force majeure condition ceases to exist. So, that way you don't lose the contract and you don't get, well, you didn't make your deliverables. No, that was paused while this force majeure was going on. Here's one that you might want to include if it's a hotel contract situation. You might also want this sort of language. In the event of a rescheduling based on force majeure event, all attrition and cancellation penalties under this agreement shall be waived. Because most of those contracts for hotels have those kinds of details in there. What happens while we're on pause? Well, this would make it very clear that during the pause, that is waived because of this force majeure. Now let's shift gears a little bit, and I'm sure you might have a lot of questions about force majeure. That's been a primary focus in the wake of this pandemic. But cancellation policies also come into play, and the traditional ones didn't think about this sort of scenario necessarily. Consider adding in the event speaker is prevented from performing. I have speaker as an example, but yours may be a little different scenario. In the event speaker is prevented from performing the engagement live in person due to a force majeure, speaker reserves the right to perform via live webinar on Zoom or comparable platform. I'm of the mind, and some of you may be as well, that when COVID kind of gets under control, we've got a vaccine and the numbers go way down. I don't think that the online way of presenting is going to go away. I think that we've learned a lot. This is a bit of a silver lining from the event. We've learned how effective it can be to do so virtually. It's a live thing, but it's virtual. And there'll be hybrid models where there's some in-person attendance, some online. But this phrase would be helpful, I think. And then another one is if the event is canceled due to COVID-19, the deposit, say they have paid you half of your fee or a portion of your fee, what happens to that? Well, in the event it's canceled due to COVID-19, that you could put there after COVID-19 wears off a little bit, if the event is canceled due to a force majeure event, whatever the situation is. The deposit will either be applied to a virtual keynote or to a rescheduled live event within 1 year of the effective date of the agreement. So again, what happens? Do I lose the contract? Do I lose the gig? Not if we have this kind of language in our cancellation policies. New logistics. It's much different than presenting on stage live in the room, live in a training room, live in a workshop. There's some logistics that are different, and there's also some logistics that have changed because of the current pandemic. For the live events, you might want to add some or all of these. These are just some suggestions. All attendees must have their temperatures taken before entering the meeting room. You've seen some of the offices where they have a table close to the door. They've got a thing they simply put on your forehead. It very quickly says whether you're running temperature or not. That's helpful, doesn't take much time. All attendees must wear masks. That might be appropriate. Attendee seating must be 6 feet apart. Here's one that protects you. Front row of attendees must be at least 6 feet from the speaker platform. Here's a few other suggestions. The meeting room must be thoroughly sanitized at least 12 hours prior to start of event. Meeting room shall remain vacant from time it's sanitized until attendees are allowed in. Typically, attendees start showing up maybe a half hour in advance. Maybe they open the door a half hour in advance. Well, between the time it was sanitized and that 30-minute door opening, no one's in the room. Speaker will wear a mask when not speaking, but switch to a clear plastic face shield during presentation. You just want the expectations of how you are going to present, how you expect them to behave. You want to put that in your contract. It protects you, it protects them. It's a win-win for you and your clients. What about the virtual events? Well, you need to think through that. I mean, this is kind of a living example of what we went through. We did get on 30 minutes ahead of time, yet we encountered the inevitable, the technology issues. You might want to add some or all of these. They got to provide the meeting link 72 hours in advance. You may want it more out than that, but you want to make sure that that meeting link is provided by the client and you have it in plenty of time. Client will provide an experienced host. Well, we have Karen on this particular thing. She's experienced. Or the client will provide a producer. Same thing. You want this to run as smoothly as possible. Speaker will be made a co-host of the meeting. I was with this one. Here's a few others. Client host will participate in a rehearsal at least 48 hours beforehand. That may or may not help, but it certainly will make things smoother, certainly make both sides feel more comfortable. Karen told me that everything was working splendidly with this an hour ago, or an hour before we started, an hour before we met 30 minutes early. but you just want to put some precautions in place. Attendees will all be muted or non-muted to start, depending on, is this a presentation? Is this a discussion? What kind of scenario is it? You want to make sure that you have control over this. It's no different than if you were live, you want to maintain control of the room, control of the group. All attendees will have their video camera on. You see how it makes a difference with the video not working with me. As a presenter, or when you're talking to a group, you're going to want their video on. You're not going to see squares with a bunch of names. You want to make sure that you're with them, they're with you. Okay, so we've talked about cancellation policy. We've talked about logistics. We've talked about force majeure clause. Let's think about, there's typically reps and warranties in a contract. That reps short for representations. Those may be that you have the right to enter this contract, that it's not going to conflict with things, that you will follow all laws, those kind of typical reps and warranties. Let's think about some that might apply in this current situation. You might want to have the parties representing to one another that to the best of the party's knowledge, they are in good health. To the best of the party's knowledge, they have not been exposed by infected persons. There might be some disclaimers and waivers you want to make. Each party assumes all risks of infection, illness, or death by meeting in person during this time. I have drafted a number of COVID-19 releases for this very reason, because both says, no, we understand, we know the government orders, we know the numbers, we watch the news. Nonetheless, we want to have a live in-person situation. Well, I would suggest from a lawyer standpoint that you want them to state in their contract, and they're going to want you to, that you're assuming the risk. You understand there's a risk. You're assuming it, and you're nonetheless going to meet in person. Each party waives all claims of personal injury or death caused by infection at the event. The news this week is worldwide, 1 million deaths over this. That's a real thing. And you want to make sure that you're not going to be, because you came, they had a meeting because you came, and now they got infected and we want to sue you because if you hadn't come, you can just hear it go yada, yada, yada. Just put these things in your contract so that the marks are across everything that you need. Insurance considerations. I'm sure that some of you went to the insurance policies, as you should. There's both insurance that you have in place, and there's insurance typically that the client has in place. Your insurance. Is there business interruption coverage? What does it say? Is there event cancellation coverage? Okay, we've got the coverages. What are the listed exclusions of these policies? Sometimes in the event cancellation, illness is excluded. So you just have to look at the verbiage. The other party's insurance. Is there a commercial general liability policy in place, coverage for that? Because sometimes bodily injury might include sickness and disease. It depends on the specific insurance policy. You just have to look. But let's look for how can we cover some of the losses. Insurance sometimes can be your friend. Again, what are those listed exclusions? Next steps. Here's what, I'm sure you've done some of this already, but here's a list of what you should be thinking about doing sooner rather than later. Update your force majeure clauses based on some of the things we've talked about. Update your cancellation clauses. Add new logistical requirements, whether it's a live event or a virtual event. Either way, things are changing. Update those contracts. A contract is not static. It's a living, breathing thing that evolves over time. Add new reps and warranties that we talked about. Add new disclaimers and waivers. If you'll take care of some of these items, you're going to be better situated going forward. Some of the ouch kind of realities that you've realized based on your old contracts, these things are going to make you much better situated going forward. Okay, I have gone through a lot of stuff in a fast amount of time. I wanted to leave roughly half the time for you. It's your turn. Q&A. And I'm going to rely on Karen to feed me questions. I don't know how this is going to work. I will stop my share. Well,
You can leave that up.
okay, I'll leave that up.
Yeah,
Karen, drive the questions to me and I'll take them as they come.
sounds good. I already have some in the queue here, so we'll get started with that. And I would encourage everyone to continue dropping in some questions, either in the Q&A area, or a couple of you have dropped them into the chat function, which is totally fine. I'm just going to start at the top here, Russ, so we can work our way down the list. And some of these may be things that you've talked about or touched on, but we'll go through each one, and that's where we'll start.
Okay.
So our first one here is, what if you're contracting during COVID and your property, your hotel says COVID's no longer valid for force majeure because you're contracting knowing that the option is there?
If I'm understanding the question, that they're saying you know that the option of COVID-19 is there.
Yeah, that's the way the question's worded. So I'm not sure that was an
Yeah,
anonymous question,
I
but
would
yeah.
say before February of this year, maybe even March of this year, that statement's not true. You weren't aware of the possibility of what our whole world got turned upside down. Now, certainly, if you've got a contract that got entered, executed and signed during 2020, they might have something to that argument. But so I would say answer to the question would depend upon when that contract was entered.
Right. Yeah, and I think this person specifically saying going forward. So if they're contracting now and they're trying to put in some measures for something.
Yeah, I would encourage you to put in all of those, including your laundry list, all
Right.
those suggestions that I made about the force majeure, including with the hotel that the cancellation fees and attrition are waived during this event because of this event.
Great. Okay. The next question I have is, how far in advance can we use force majeure? This particular person said we need 6 months to market our event. So far, they were able to reschedule all of their events for a future year, but one of the hotels is not open yet, and we're supposed to go there in the spring. I don't think they're going to reopen, and they are not letting us out of our contract. What to do?
Well, if they don't open, in time, then I think you might turn even to the frustration doctrine that I spoke about, because if they're not open, it's not possible for you to perform. It just depends on the facts as they unfold. It depends upon the language in the agreement. I'd love to look at that and make some arguments based on the things we talked about. It's not just force majeure. Is there a cancellation policy in there? What does it say?
Right.
But certainly, if the stubborn hotel is not letting you out of it, but they're not going to open or reopen, then the answer to me is, well, you're making it impossible for me to perform.
Right. Okay. And just so you know, Russ, we are keeping, we will keep records of all of this, all of the questions here for you today. That way, when folks get in touch with you afterwards, you have all of this as well. So
yeah, it'd be great. And the last slide I'll put up when we finish this Q&A has all my information for everyone.
Perfect. Perfect. All right. Next question. Is there a right time for when force majeure kicks in? And what do you do if your venue doesn't want to address until it's too late for the group to wait to address from a logistical and planning standpoint?
Okay, so how I'm interpreting the question is that it's not technically too late by the contract language, but because of the nature of the event,
Right.
It's now practically too late because they can't. It's just impractical now because of the time. Is that how you interpret the question?
That's how I'm reading it. So if that's different, I encourage whoever to put that in the chat. But yeah, that's how I'm reading it.
Yeah, I mean, it's all going to depend on each of those things in there. A, was there a force majeure event in the list or the catch-all? B, what was the standard for the force majeure triggering? Was it, impossible, practically impossible that, you got to go through that analysis. And then you got to get to when did the notice period begin and what is required with your notice. So make sure that you even have complied with the contract itself. But, I think it would behoove the parties, both of them. And hopefully going forward, by the way, you're going to have some language about rescheduling and that sort of thing, but it would behoove both parties. It's in their both the mutual best interest to work this out. You can always work things out despite that there's no provision in the contract. It's better if there's something in the contract that you can hang your hat on, but hopefully you've got a good relationship with the other contracting party and you point out the positives for them. Look, it's not practically possible now. Can we put this out, X number of weeks or months, whatever we need to do to make this a successful event for both us and you. And you just go into you put your negotiation hat on there and say, look, it's really not addressed in the contract. And if we held it to the literal interpretation of the force majeure clause in this particular contract, that's not good for either one of us. So you try to help them see the advantages of working with you on it.
Okay. Next question. Is the frustration common law precedent also true internationally?
I don't know. I'm not an international attorney. What you would need to do is you would need to, you could do some research on your own, this wonderful internet, before you engage counsel, or you could engage counsel here to look into it. But, it depends on the country, the territory you're talking about. You look to their law and see if in their body of law there is the similar doctrine of what if contract performance becomes impossible, and they may call it something different, but they may have something very like the frustration. Or you may have in your contract that even though they're situated internationally, the contract provides that U.S. law, certain state in U.S. applies, and that they have consented to that law into the jurisdiction. So, by the way, if you're a stateside company that's doing contracts with international partners, I would start there going forward, trying to get them to consent to our law applies. But if you don't have that, look to their law. If you need an attorney to help you look to their law, that's what you would have to do.
Okay. As an independent planner, I'm more concerned now about making changes with regard to legal language in contracts and leaning more toward completely leaving language changes, such as force majeure, to my client's legal team to avoid repercussions. Can planners be liable for, quote, practicing law without a license by making legal language changes recommendations?
No, if you're not advising other people, you are not practicing law. You have every right as a layperson, meaning not a lawyer, to write your own contracts. I don't advise it in most instances, but you can. And that's not practicing law if you are working with your contract or a contract to which you are a party and you are trying to adjust the language. Now, it's much different if you start advising all others in your industry and you start say you need this, and you get closer to practicing law when you're making advice to other parties. You can always advise yourself and not be guilty of practicing law.
All right. Let's see. What if you already have a contract and you're trying to reschedule? Example, conferences in Florida in January, and they also have conferences in Florida in April and June. We have surveyed participants, and more than 90% of people cannot travel due to corporate or university restrictions. The meeting is impossible to conduct because people cannot travel. Hotels are saying that it's too soon to invoke force majeure. So what's your suggestion, I guess, is what they're asking, and how to handle that contracts wise?
Yeah, well, I certainly would put the hotels on notice that, you don't want to just be silent about it. Put them on notice to say, as we sit here today, if we were talking about today, the force majeure applies. Now, I'm not giving you notice yet because the event is so far out and our contract language is blah, blah, blah. But just be on notice. It always helps to manage expectations, keep business partners in the know of what's coming. But I would have to look at the contract language, and I would have to see if there's any kind of argument that, based on what are the orders that are in place, whether they're state, local, or federal. It all depends. And a lot of people accuse me of being the it depends guy, but it does. It depends upon the set of facts and what the document says. So, I would just put them on notice that, hey, this is where we are today. And hopefully they'll see the light as the time gets closer, that even though, okay, technically force majeure hasn't been invoked yet, but it's certainly looking like that's a very real possibility. Shouldn't we be talking about putting the event out farther on the calendar? Or the other thing I would say is virtual possible?
Right.
You might want to be able to do it that way. And it could be a hybrid event where maybe some people are there that are locals, but others can't travel because of either their company policy or because of a government order, what have you. Those folks could participate by virtual, and you'd have a hybrid event that could be very successful.
So this is kind of interesting. It's, a lot of the questions here are, it's the same topic, the same concerns, but just variations. So this person said, we've come across some hotels that are taking COVID language out. I know they are protecting themselves, but we also need to. I'm seeing this more often than not. Any suggestions on how people are compromising with both, with the meeting planner side on that end and then the hotel?
Yeah, I wouldn't have a problem taking the words COVID-19 or coronavirus out, so long as there are other words or phrases in there that if we had another COVID-19 kind of event, or if there's a huge relapse of COVID-19, we'd have something in that force majeure to hang our hat on. Naming COVID-19 and coronavirus is not the key. The key is having something that sort of thing falls within. So you might want to have, hopefully they'll still allow you to have quarantine, government orders. You might be able to have in there national or worldwide epidemic. They might be okay with that. They don't want, say their county has a huge flu outbreak. They're not going to want you to be able to get out because there's a huge number of flu cases in their county. But certainly if it's COVID-19 is a little different. You don't need those magic words, but make sure you've got one or two, hopefully two or three, because you may have to argue each one of them. Does this event fall within one of those? I hope that answers the question. Just, you can give them a little feel good, say, I don't mind. Yeah, we can take out COVID-19, but all the while, either knowing that, some of the other phrases in there that they are not asking you to take out would cover it, or you say, I'll take out COVID-19 if we could replace it with X.
Right. Good. I think that's a good place to start, at least.
Sure.
Conversation to have. So in regards to speakers, we booked a speaker in person before COVID-19. We then rescheduled the speaker for January of 2021 with an amendment. Now they just found out today that the client may cancel this rescheduled meeting using a pandemic credit through December of 2021. So the contract and amendment, my contract and amendment has a lot, but it doesn't address a second cancellation or rescheduling. Not sure how to handle.
Yeah, I'd love to see the contract to give you a more complete answer, but think about and broach the topic of the virtual event. Look to, make sure you look at all of the things we talked about, cancellation policy as well as force majeure. Um, a lot of times, well, if it's a speakers bureau, for instance, or a speaker broker, you probably have two contracts. You've got one between you, the bureau, and your client, and then you've got one between you, the bureau, and the speaker. It'd be interesting to see how those match up together. But I think you just got to, you can't always rely on the contract. Sometimes you just have to say, look, this is not really addressed. How are we going to deal with this? It's in all of our best interests to find a workable solution. You just put on the can do kind of negotiation hat. Um, but if you would like me to take a look at the exact language, I could probably give you a more full answer.
Great. All right, let's see. We still have questions coming in, which is great. What if the local government says hotels are open and health officials are still saying that no more than 10 people are supposed to meet? Hotels are opening up at 50% occupancy with 6-foot social distancing. Can the group invoke force majeure and walk away without penalty? I know, again, that's what's in your contract question.
Yeah, I wonder if in a particular contract you have something about you will comply with all laws, ordinances, and that sort of thing. And then I would say I would rely on that. Say you're asking me you're asking me to breach the contract because the contract says I have represented and warranted that I will completely comply with all laws and ordinances and that sort of thing. And in this particular scenario, you have in your state or in your county these particular active orders that have not been rescinded, and I cannot violate those. I would be in breach of the contract. That's kind of the way I'd go about it, and I would follow it up by the way, you are putting yourself at risk in violating your own state or county's government orders. It might not be where they could arrest you, but it certainly could have ramifications and the kind of public relations issues that it's just going to harm you more so than insisting upon this particular scenario. So let's find a way where we both can do the right thing.
Yeah, I think if you said that to me on the hotel side right now, I'd be changing my mind immediately.
Yeah.
I
mean, and it could be a big chain where somewhere else the mothership, the headquarters is saying you are to maintain, because they're worried about revenue, obviously, and they may have some company policies and mandates in place that they're fighting with.
Right.
So they might appreciate you giving them some ammunition that they could take up their own chain of command.
Absolutely. Great answer. Great. All right. Let's see. What do you do with a hotel who won't accommodate groups in Q1, Q2 of 2021 right now? They're saying it's too far out to call it, but in the contract it states pandemic. Doesn't matter when I call it?
Well, I would pose the question back to you. What does your contract say about when does the force majeure trigger? In other words, we had the whole scenario with COVID. When did it start? With which order? So has the time even started? It may be a moot question if it hasn't started. If it has started, how much timeline do you have? How much flexibility? Because if it has triggered, the starting period has happened, you want to be darn sure that you comply with what is required, whether it's promptly, immediately, X number of days, whatever that is. So it's a two tier question. Has it started? And if it has, how much breathing room do you have? You may be forced to call it because if you let the period of time in which to call it expire, then you got a bigger problem.
Right. I'm trying to decipher this next question. I'm going to read it out loud and see. It says our hotel for 2021 is not open yet, and we don't know if they're going to open. If they don't open, we are totally released from the contract, correct? What is the hotel's liability on this? If they don't open, and we are stuck without a hotel, so that puts us on a bind. Is there anything we can financially collect from the hotel? I mean,
Well, I think it would depend upon the reason they didn't open. If there's something that beyond their control that they simply couldn't open, then maybe not. But if they consciously made the decision that they're just not going to do it, then yeah, they've got risk in place. You know, of course, they're going to argue that, you know, if they had a reason that they couldn't open, that, you know, their contract was, their side of the contract was frustrated because, you know, they can't control it. It's unexpected, and there's nothing they can do about it, but it certainly makes their performance impossible. So again, it always depends upon the facts.
Okay. If you have a notice period of 10 days for COVID-19 in your contract,
Okay.
enter a contract today, does the notice period eliminate force majeure since COVID-19 started in February? Or is a pandemic considered a fluid event, and therefore, since the pandemic is constantly changing?
Yeah, so I understood the question, correct me if I'm wrong, that let's say you're entering this contract today, and we've had COVID going on in this country at a pretty alarming level since March, but it's still going on. Is that the
Right.
scenario?
That's what it sounds like.
Yeah, I would behoove you should look at changing that force majeure clause, adding language in it, you know, that in this particular contract, you probably wouldn't do this in all of your force majeure clauses, but in this particular contract, you'd probably have some verbiage in there about the scenario. Say that, you know, if we are both entering this agreement, knowing that COVID-19 is still very much in play, and unless things change, we will not be able to deliver, perform, you know, meet our obligations, that sort of thing. You know, I would have to sit down and I would have to take your scenario exactly, okay, what it is that both sides are doing, what's your performance, what's their performance, and how does the scenario now. But the bottom line answer is I wouldn't sign that contract if it has, you know, just has COVID-19 in there, because you do have to address based upon the timing of, because you're basically signing a contract that already force majeure is in play.
Right.
And that doesn't help either side. That, you know, that's not the spirit of what a force majeure clause is for. You enter a contract expecting that both sides will perform. You have the force majeure in there just in case Chicken Little, the sky starts falling. But otherwise, you both intend to perform. But the question kind of gives me the impression that you're both entering a contract that you're both aware of. Neither of you may be able to perform, and you just don't want to set yourself up like that. You've got to address changing the verbiage, adjusting the verbiage in that force majeure for this contract only, maybe.
Okay. Let's see. Hey, that's person said, I just don't understand if the contract lists pandemic as a condition under force majeure, no matter if the program is set to start today or in 2022. Why can't I evoke force majeure now? What do you do if the hotel just says no? Litigate?
Yeah, you might end up litigating, but you know, the problem with entering it now is, say the event is in June of 2021. Yes, you could say a pandemic has hit, I'm invoking the force majeure clause. The problem with that is the timing of your performance isn't until June of 2021. And you may very well, the force majeure may very well still be valid, because you followed the letter of the language in the force majeure. It was triggered. You gave them notice within the required time, so you have invoked the force majeure. But again, none of us know what's going to be the scenario in June of 2021. And so I would argue the same thing from the other side, say, well, that's all well and good. Yes, you've complied with everything that's required to invoke the force majeure. But we take the position that the force majeure event may alleviate before the time for you to perform. And if it does, we expect you to perform. Force majeure is all about you can't perform because of something beyond your control. And right now, that's true. But your ultimate deliverable isn't until June 2021. And understand that our position, this is them talking, is that you've complied, but just know that the force majeure may alleviate before you perform. And if so, we expect you to perform. So that's the situation you're in. I would say if it's triggered and you need to give them notice, do it. But you have to realize that the force majeure event may go away.
All right. I have two more in the queue right now, so I'll see if any more come in. Let's see. If the force majeure in my contract doesn't specifically, and I know this was, I know that this is when, in March and April, this is where everybody was like, what does my force majeure mean? What's covered here? But the question,
Right.
if my contract doesn't specifically list pandemics, but includes, quote, or any other emergency of a comparable nature beyond the party's control, quote, would that include COVID?
I could argue that it would. It would, of course, in the end, if they disagree and you end up either in arbitration or mediation or in a litigation, it's going to depend upon the decider as to whether they buy your side or their side. But certainly, the COVID-19, I would say, has been a national emergency, certainly a local emergency. And so, yeah, I could make a very straight-faced, good faith argument there. I think there's merit. Hopefully there might be some other things in the laundry list that you could also argue, like Government Act. But yeah, I think you could make that argument.
Well, and I think that's helpful too. And one of the earlier questions that was asked, if they want to take out that language for COVID-19, something like this, which is a little more broad,
Yeah.
might be a good common place to meet.
Yeah, I mean, it's certainly better than nothing, because
Right.
anyone that would suggest that COVID-19 has not been of an emergency level, they've got their head buried in the sand.
Exactly. All right, let's see. Oh, I have some more questions that have come in. We have a little bit of time left. Let's see. Although we are under social distancing measures now, it's not a fact that those same measures will still be in place next May. No one knows. Given that, should a hotel have to absolutely prove that they can accommodate our group next May? Should the 6-foot requirement still be mandated? I say no. They can't be held to a standard now that won't necessarily be in existence next year. I welcome your counsel.
Yeah, I think that's right. It kind of like the other question, you could say that I think you ought to have the conversation. If this event were now, could you accommodate it? If they say no, then you need to suggest that, well, what do we do so that we're both have some comfort? You can always amend a contract, add a number or something. Say, what could we add that would make y'all comfortable and make us comfortable for that scenario? Maybe you put a range in your contract. Right now it's 6-foot distancing. Maybe you put something in there like 6-foot distancing or a comparable effective measure, something like that. Because I think that even after COVID has kind of waned a little bit, it's always going to be on the conscience of people that attend, people that say, if that's a hotel event situation, people that are buying their rooms are going to have it in mind, regardless of whether there's a vaccine in place and the numbers are a lot lower. It's still going to be top of mind. And so it's in their best interest to have something in the contract that they can point to with their customers that says, here's what we're going to do. And yeah, it might not have to be 6-foot distancing, but if you had verbiage in there that said, or based upon the then current circumstances, would be of a similar precaution, something like that.
Okay. It's funny that in your earlier example, you brought up June 2021 because one of the questions on here was specifically that. I haven't, in June 2021, can I use the FM clause? But then a follow-up question is asking if the group invokes force majeure with the venue now for an event in June, are you saying that the contract is still in play until June 2021 to quote, see if the group can perform? They just want to confirm that.
I would say, without knowing more, I would be able to argue very strongly on the other side that yes, we are not going to consider this contract terminated because force majeures are only in place for the time period that the force majeure event preventing us from performing is in place. And neither of us know what that's going to be in June. So we do not consider the contract terminated. We will wait and see. But I'd love to look through the agreement, to fully answer your question, because there may be other contract language that, that we haven't covered the universe of contract possibilities in this webinar. There may be language in there about diligence and those kinds of things that we could hang a hat on. It just depends on the particular contract verbiage. So look elsewhere in your contract and see if there's anything that, okay, well, how would that apply to this situation? And it may be that it was, neither side intended that language was in the contract for this kind of thing, but it nonetheless, as worded, can be applied.
All right. I think I have one more here now for you. And again, I've been keeping track of all of these, and so I'll throw this out there, and then I'll let you end with some information so that folks can reach out to you and get more counsel. Sure. This has been amazing. So the last one I have here, I do not have a force majeure clause in the agreement, but I have an impossibility clause, and it states terminate as soon as reasonably possible. Can I use this for a 2021 event?
Well, I would say when in 2021?
June.
June?
Yeah.
I certainly, you never want to just be silent. You want to send them notice under the contract so that they don't have the argument later that you missed the window. And again, I know we're not talking about force majeure, we're talking about an impossibility clause, which basically, even though it's not called force majeure, it could be considered a force majeure. It also could be considered a codification of the common law, case law notion of frustration. But depending on what it says, you don't let the window of time get away from you. Go ahead and give notice. But I would have, again, I'm sorry, these kind of categorical questions without having all the benefit of the contract is tough to answer because it really does depend on that contract verbiage. That's what the judge or jury is going to say. They're going to say, what is within the four corners of this document? And so hopefully there's something in there that would help you in that scenario.
Well, this has been absolutely wonderful. I'm going to, again, get all these questions to you. And I know we may have some others that'll come in. I encourage all of you. I know Russ is going to put up his information here to get in touch with him. Obviously, there's a wealth of knowledge and in contracts. It's, it's whatever's in writing. So. Oops.
I'm sorry that went away. Let's get it back up there.
That's okay. I'm going to actually put a little note in here regarding some of our upcoming webinars that are also coming. We have one from the hotel perspective next Tuesday, and then another one on sponsorship on Thursday. But Russ, I'm going to give this back to you to let you end here. And we really appreciate you taking this time. I know this is COVID and contracts are at the top of the list of the 2020 conversations in this world. So we really, really appreciate you doing this.
Yeah, it's a lot of when if we're just talking, uh, some of you are probably saying this isn't fun at all because you've got a particular contract in mind. But talking about it in general, like we just did, it can be a lot of fun thinking about all the scenarios. Uh, it depends on your facts. Gather your facts, consider the circumstances, and then what does your contract say? And what kind of a relationship do you have with the other party? Regardless of what the contract says, is there a conversation to be had? I have the philosophy, and I think it's true based on my 30 years of experience, is everything is negotiable. Maybe I used to think, except for taxes and death, that there was that phrase in place. But if that were true, there wouldn't be all this plethora of companies like Optima Tax Relief and all this that you see on the television of how they can help you get some things wiped out. So maybe that's not non-negotiable. And I used to think, well, okay, well, death is non-negotiable. I think dying is not negotiable, but how you die may be. My father he was on dialysis and then he got cancer and the doctor gave him a choice and he chose how to die. He just stopped his dialysis, a lot less painful.
Yeah.
So always have the mindset that everything's negotiable. And if you've got a good relationship with the other side, we could do a whole webinar on negotiation tactics and how you can get your best results. But anytime you can point out how it benefits them, you could probably persuade them. So what are the facts? What does the contract say? I've got a good relationship. Let's just have a conversation. All of those things. And if you have any doubts about what the contract says, get some advice. That's not a sales pitch by me. You can choose anybody you want, but get some professional advice. And certainly, please have learned from this webinar and our discussion and take some action steps going forward, because you might can fix what's in the past, but you can certainly ward off problems in the future by some of these things. God bless you. I've enjoyed being with you.
Absolutely. And we look forward to having you again in the future. Thank you so much, Russ. And
thank you,
everybody, for being here today and working through our small technical issues. But, the rest of 2020. All right. Thanks a lot.
My best to everyone.